Hello, welcome to our webinar. Brexit is coming. We've heard these words on the imminence of Brexit at least twice before. This time, all the signs are that the next date is the real thing. The transition period agreed in the Brexit withdrawal agreement will terminate on 31st December 2020. Whether there is a new trading deal or not, the implications of this next deadline are the same for brand owners. Potentially, the transition period could be extended, but that now seems very unlikely. If it is, we don't anticipate anything in this webinar would change but for the timing. It means we can just replay this recording another time. Realistically, it is high time for brand owners to consider carefully what action is needed. During the next 45 minutes or so, we will look at how Brexit impacts on portfolio management, on current and future disputes, and on trademark-related agreements. With me are Louise Popple and Roland Mallinson from Taylor Wessing, London. Louise is a lawyer in the IP and media team in London with over 20 years' experience. She is currently responsible for the team's knowledge and training. Before that, she was a senior associate in the team. Her careful scrutiny of recently published draft official Brexit documents has led the UK government twice to withdraw their documents and republish it with Louise's corrections. Roland is a partner and head of Taylor Wessing's UK trademark practice. He's had an active involvement in Brexit and IP issues ever since the 2016 referendum. As chair of the Marks Brexit Task Force and as a member of the UKIPO's Trademarks and Designs Forum, he's been interacting with both the UKIPO and the EU Commission about the transitional arrangements. My name is Sebastian Fischöder. I'm a partner with Taylor Wessing in Germany, based in Düsseldorf. I have nearly 20 years' experience in strategic brand advice, as well as national and cross-border brand litigation. 3 housekeeping points. This webinar will be recorded. We will share the recording. If you have questions, please send them in the chat option, and we will try to address them at the end if there's time. And the last housekeeping point, after the webinar, you will be asked for feedback, and we'd be grateful if you could let us have yours. And now we will start with Louise on portfolio management. Louise.
Thank you, Sebastian. So just a very quick recap. I seem to have gone forward on the slides too much. Just a very quick recap on how EU trademarks will be dealt with at the end of the transition period. Trying to get the slides to get to the right place. Right. So, as of 1st of January 2021, EU trademark registrations will no longer cover the UK. However, if you have an EU trademark registration in existence on that date, you'll be given a new national UK registration automatically and for free. And these will be called comparable trademarks EU. So my slides are misbehaving. Hopefully you'll be able to see what you're supposed to see right now. So you don't need to do anything to get these comparable UK registrations. And they will have the same priority, filing, seniority and renewal dates as the EU trademark registrations from which they derive. The position will be slightly different for EU trademarks that are pending on 31st of December 2020. If UK protection is required, you'll have to file a separate application in the UK for that mark and pay the usual UK application fees. These refiled applications will be examined afresh and can be opposed all over again in the UK. The fact that an objection or opposition has been overcome for the corresponding EU trademark application will be relevant. However, if the UK application is filed within 9 months of the end of the transition period, so that's by the 30th of September 2021, then it can claim the same priority, filing and seniority dates as the corresponding EU trademark. And this applies irrespective of when the EU trademark was filed. So you could have an EU trademark application that was filed back in, say, 2017, and it's still pending at the end of this year. The applicant can apply for the same mark in the UK any time up to the end of September next year and claim that 2017 filing date for the UK application. So what we're going to see is some very new UK applications next year, which have very old filing dates rolled over from the corresponding EU trademark. Amongst other things, this means that for trademark clearance searches, you should include a review of EU trademarks at least for the next 9 months. Lastly, international marks designating the EU will be dealt with in the same way. So a number of things flow from all of that in terms of portfolio management, trademark clearance, in terms of disputes, and we're going to touch on some of that today. But for completeness, we've prepared a checklist for brand owners setting out all of the matters that we think you should be considering. Please do have a look at that after today's session. There's a link on the slides which we'll be forwarding to you after today's talk. For now, we just wanted to highlight a couple of things around international marks and rights of representation, because these have been somewhat overlooked and haven't been written about in detail. So for international marks designating the EU, you'll get a comparable UK registration, as I just outlined. However, that comparable UK right will obviously be a national UK right that doesn't form part of the WIPO international system. So that means you'll have to renew it and administer it separately from the IR from which it derives. And that, as you all probably know, will make managing the mark more costly and time-consuming. However, there is a way of bringing that comparable UK registration back into the IR system. And you can do that by using a process known as replacement, which is a specific process unique to WIPO. I'm not going to go into detail on how that works now. We have summarised what you need to do in the checklist I just mentioned. But for now, we just wanted to flag that this is possible to bring the comparable UK right back into the IR system. There's no urgency to do this, so everything can be done after the 31st of December. There is, however, a cost involved, so it's going to be something that is considered on a mark-by-mark basis, I think, to see whether that cost is merited. The second issue is on rights of representation. As you may know, UK-based representatives can't continue to act before the EUIPO going forwards. However, there's an exception to that rule, and they can continue to work on any matters that are pending 31st December 2020. New guidance has recently come out, which is very useful on this, and that guidance tells us that this exception does not apply to employee representatives, so it only applies to professional, or we might call external, representatives. What this means is that those with in-house UK teams that are used to handling EUIPO matters are now going to have to appoint either an EU-based representative or an EU-based employee to handle all of their EUIPO matters, and that includes those matters that are pending at the end of this year. So I'll now hand over to Sebastian, who's going to talk about the impact of Brexit on pending EUIPO actions.
Thanks, Louise. So what will happen to proceedings before the EUIPO, which are
We seem to have lost Sebastian. Maybe I'll continue until he rejoins us. So Sebastian was asking what happens to EUIPO actions pending at the time of the 31st of December, which will involve UK prior rights. And there are 3 basic rules for that scenario. The first is that the UK prior rights involved could be a UK registered trademark or a UK unregistered passing off right. And these rights can no longer be relied on in oppositions or cancellation actions decided after the 31st of December this year. Any reputation earned within the UK for an EUTM will also be disregarded by the EUIPO if the decision is after the 31st. But in contrast, use of an EUTM in the UK will still be relevant as genuine use within the EU, where that use was in the UK before the 31st of December and within the relevant 5-year grace period. However, the EU IPO has still made it clear that the extent of that relevance may decrease. Essentially, the more historic the use, the higher the risk that it will be deemed of less relevance in decisions coming after the 31st of December for proving genuine use within the EU. So how do these rules work in practice? Well, let's consider the following straightforward scenario. You attack the EUTM ripasse on the basis of the UK trademark riposse at the EU IPO. Either this is done in an opposition or an application for an invalidation. As from the 1st of January next year, the EU IPO will disregard UK rights as prior rights. The EU IPO will then dismiss the opposition or the invalidity of the application. Let's imagine a different scenario. You attack the EUTM ripasse on the basis of the EUTM riposse. The attack claims the likelihood of confusion and dilution. However, the EUTM only has a reputation in the UK and nowhere else in the EU. In this scenario, presuming the decision comes after the 31st of December, the EU IPO will ignore the UK reputation. And that may weaken the likelihood of confusion argument and the dilution claim may fall away. The EU IPO can still decide the case on the basis of likelihood of confusion, but it's just treating the EUTM as having no enhanced reputation anywhere in the EU. So there are two important takeaways here. Any new or pending actions to be taken at the EU IPO now need to rely on non-UK prior rights and on non-UK reputation. And if put to proof of use, we're relying now on very historic use in the UK alone to prove genuine use. I'm going to be talking now about EUTM cancellation actions in the UK. So let's consider what will happen when an EUTM registration is the subject of a challenge that is still pending at the EU IPO on the 31st of December. It could also actually be a challenge pending in an EUTM court within the EU. So if that decision is against the EUTM, then the newly created UK comparable right will also be lost as the default position. Note, this only applies to cancellations against existing EUTM registrations. It doesn't apply to pending oppositions at the EU IPO. And this is just remembering that there's no newly created comparable UK right arising out of a pending EUTM application. It also doesn't apply if the grounds for the successful cancellation decision would not apply in the UK. So what does this mean in practice? Well, let's say we have a cancellation action against the EUTM ripasse that won't be decided until after the 31st of December 2020. The attack is based on two riposse rights. The first is a German national registration, and the second is an EUTM registration. And this riposse mark has a reputation in Germany only, and let's even say it's never been used in the UK. If the EU IPO or EUTM court decision leads to the ripasse EUTM being cancelled, the default position will be that the new UK comparable right coming out of that EUTM would also be lost. But that may not be the final outcome. And this is because the owner of the new UK right, i.e. the losing party at the EU IPO, will have an opportunity to convince the UK IPO that the same decision would not have been made in the UK. It will have 2 months to make its case to the UK IPO. To do so, it will need to show either that the EU IPO's decision was based only on the German national prior right, and this does sometimes happen in EU IPO decisions. They choose just the closest prior right, and it may be that in this case, the German mark had a closer overlap with the goods and services, so they didn't decide on the earlier EU trademark. Or the EU IPO's decision on likelihood of confusion was dependent entirely on the German reputation or the perception of only the German consumer. Perhaps there's a conceptual similarity that the German consumer would have and the English consumer, UK consumer would not. Or the dilution and free riding claim succeeded, and since there's no reputation in the UK, that claim clearly would not succeed in the UK. So the UK IPO then decides the fate of the new UK comparable right. Note that that process is not contested. So the successful cancellation applicant at the EU IPO cannot make any submissions at the UK IPO at this stage. If the decision goes against them, they still have the opportunity to just cancel the new UK comparable right in separate proceedings at the UK IPO. We're now going to consider what happens to proceedings that are pending before the UKIPO on the 31st of December. So here, and this is where there's a prior EUTM right in play. This might be an opposition or a cancellation action before the UKIPO, but it could also apply to a counterclaim in a UK court, in fact. It's simpler where the prior right was an EUTM registration. The UK action will simply continue just as before, but with the prior right now being the UK comparable right. If the prior right was only a pending EUTM application, then there's no automatically created equivalent prior UK right for the opponent. As Louise has pointed out, there's just a temporary option for the opponent to file a new UK application with the same priority date. So it's likely the UK opposition will be suspended, waiting to see if the opponent files that new UKTM application, and then it seeks to rely on that as a substitute prior right in the opposition. That means this case could be on ice until at least the 30th of September 2021, and in fact, until that application is either granted or refused, which might not be until sometime in 2022. The potential for complication arises where the prior EUTM being relied on in the opposition has never been used in the UK, the registration is more than 5 years old, and it has a reputation, but only outside the UK. As stated here, the reputation may not help, but at least the use will. And so it's perhaps easiest if we consider an example. In this case, we've got an opposition against the UK application for Repassa based on a prior EUTM registration for Repassa, which is more than 5 years old. The Repassa mark is well known in Germany and isn't used at all in the UK. So, as before, the opposition continues based on the new UK comparable right. Since there's no reputation in the UK, the reputation claims fall away, but they would have fallen away under the current regime anyway, so there's no change there. And it doesn't matter that the mark has never been used in the UK, so long as the use could be shown somewhere in the EU within the last 5 years. So the use that's been going on in Germany to date will be enough. Now, I'm not sure we've got Sebastian back, because the intention was he was going to talk about EU infringement.
Do you hear me? So
we now do, Sebastian. So you are now on for EU infringement proceedings.
Okay, yeah. Yeah, back again. Brexit will heavily affect EUTM infringement proceedings in future. Brexit will affect jurisdiction, service of claims and documents, recognition of judgments, and cross-border enforcement. In our current pre-Brexit world, things are clear. For example, jurisdiction. In case a claimant wishes to obtain a EU-wide injunction order, the EUTM regulation contains special provisions on international jurisdiction for such pan-EU relief. You may perhaps remember, in the first place, it's the courts of the member states are competent to grant such EU injunctions where the defendant is domiciled or has an establishment. In the second place, it is the courts of the member state where the claimant has its residence or an establishment. And in the third place, it is the courts in Spain as the country of the seat of the EUIPO. To illustrate the changes, let's consider the following example. The claimant in Germany wants to sue the UK-based defendant for EUTM infringement. As you can see, in the left-hand column, that's the pre-Brexit or current scenario, things are as follows. The claimant must sue the defendant in the UK if he wants pan-EU remedies in one court. The UK court can then grant a pan-EU injunction covering all EU member states, including the UK. Under the current EU rules, claim and document service may not always be quick or cheap, but the rules are clear and mostly work smoothly. The middle column shows how things will be very different in a post-Brexit world. The German-based claimant must sue in Germany to get pan-EU relief. He no longer gets this from the UK courts. For UK relief, the claimant must initiate a separate infringement action in the UK based on his new UK comparable right. the rules relating to service and recognition and enforcement of judgments will be much more complex, dependent on the UK's participation in treaties and conventions yet to be finalised. For now, we know that the UK has applied to join the Lugano Convention of 2007 on jurisdiction, and the UK has expressed an interest in joining the Hague Convention of Service of Judgments and Documents of 1965. But the timing and impact of all this remains uncertain, and for now, is subject, it seems clear at least, that the rules will be less claimant-friendly. As if our German claimant hasn't enough legal uncertainty in future, Roland wants to mention an additional risk. Roland, tell us about it, please.
Yes, thanks, Sebastian. So it's this more EUIPO torpedoes from UK defendants point in the middle there. This is a defendant's tactic that already exists. However, it's likely to be used much more often, we think, by UK-based defendants who fear now being sued in a foreign EU court which has the power to grant a pan-EU injunction and damages against it. A UK defendant expecting such a claim after the end of this year may choose to take preemptive action in an effort to dissuade their opponent. If they get an attack against the EUTM filed at EUIPO before the infringement claim is started, then the claim has to be stayed until the attack is finally decided. And this tactic can be effective even if there's no merit at all in the attack. The counter tactic is just to sue the UK defendants in the relevant EU court without warning. Now, the regrettable downside of all this is that it encourages parties to start legal actions without talking first. So there is a risk that disputes between UK and non-UK parties will now be somewhat more confrontational and therefore more expensive. I'll hand back to Sebastian to complete the picture.
Thanks. And we now turn to the right-hand column. That column deals with cases pending on 31st of December 2020. There is some solace for those who have brought a claim before that date. According to the withdrawal agreement of 2019, the UK court in these pending actions should be applying all EU legislation as if the UK was still an EU member state. That means the UK court would retain its international jurisdiction to grant pan-EU injunctions and even to cancel European trademarks upon counterclaim for all cases that were pending at 31st of December 2020, but not decided until long after, perhaps even in 2022. Apart from that issue, the parties of pending procedures also retain all the advantages of EU legislation in terms of jurisdiction, service and enforcement, even after 1st of January 2021. Roland, you wanted to add something on the jurisdiction point in this context.
Yes, thanks, Sebastian. So strangely, very little has been written or announced about the point that Sebastian was making just then, about the UK court's powers in cases pending now or perhaps started within the next 70 days or even started on New Year's Eve this year. Whilst we think the position ought to be reasonably clear, the UK Brexit legislation is not explicit about this, and the UK government's guidance notes are vague and potentially wrong about this. The uncertainty appears to have rubbed off onto at least one English judge who's recently granted a pan-EU injunction, but only to remain in force until the 31st of December this year.
Yeah, this is certainly regrettable. It means the UK courts will need to decide whether they have those ongoing powers in these pending cases. It will also mean the national courts of the remaining 27 member states and or the CJEU will need to resolve whether those UK decisions will be recognized and enforced outside the UK. If you are in such an action, there are some interesting arguments to be run, so seek advice. Our next scenario is the reverse of this one, and I'll hand back to Roland for this.
Things are a little clearer in the scenario, actually, in the scenario where the claimant is based in the UK and it wants to sue a German-based defendant for EU trademark infringement. To get pan-EU relief now, it must sue in Germany. The current rules make it easy to serve and enforce. After the 31st of December, so the middle column here, the claimant still has to sue in Germany, but the relief is now pan-EU 27 only. There's no UK relief, and in this case, it will need to sue in a separate UK action for infringement of its new comparable UK registration. The rules for service and enforcement are uncertain for now, but we can safely say that they're going to be more complex than they are currently. If the litigation is pending on the 31st of December, on the right-hand column, then the German courts can continue to grant a pan-EU injunction that will cover the UK too. It's anticipated that this would be recognised and enforced by the UK courts, provided the comparable UK right and registration remains in force and hasn't been surrendered or cancelled and revoked in the interim. There's actually another potential torpedo in this sort of scenario, which could be fired by the UK defendant here. That's if it wants to avoid or defer the injunction having been granted elsewhere, biting in the UK. This would involve filing a preemptive attack against the UK comparable right at the UKIPO.
So next slide. So to summarize the litigation position, if you are considering suing a party for cross-border EUTM infringement, there are procedural advantages in bringing your claim before 31st of December 2020. These advantages relate to jurisdiction, including international jurisdiction for pan-EU relief, potentially, service of documents, and the recognition and enforcement of the judgment. If you wait and want relief in the UK and in the rest of the EU, you will need to bring separate proceedings, and the rules will make it more complicated and costly than now.
And UK-based defendants will now be sued outside the UK by claimants wanting pan-EU relief in one court. So this will be good news for EU27-based claimants who can now sue in their home courts, but equally, as I mentioned earlier, may lead to preemptive actions on both sides. For non-UK claimants wanting pan-EU relief, they will now need to sue UK defendants in a Spanish court. So this might apply to a US claimant, since neither is domiciled in the EU. In fact, the same applies to a UK claimant wanting to sue a non-EU defendant. Now, if both parties are English-speaking, they might choose to agree to have their infringement and validity dispute resolved at a pan-EU level elsewhere. This leads us neatly into the topic of trademark agreements, which Louise will start with.
Thank you, Roland. So, as Roland said, we now turn to trademark-related agreements, such as coexistence agreements, cease and desist undertakings, and license agreements. For those that have historically always used English governing law and jurisdiction for all their agreements, there's somewhat of a wrinkle now if the subject matter of that agreement concerns the validity or infringement of an EU trademark. And that wrinkle arises because the UK courts will no longer be able to rule on such matters. So questions of infringement or validity of an EU trademark will need to be determined by an EU trademark court. That means a court in an EU27 member state. Roland mentioned the prospect of US and UK litigants having their EU trademark disputes resolved on a pan-EU basis in a Spanish court, I think it was. And that's a scenario that both parties might want to avoid. And they can do that because under the EU trademark regulation, there are rules allowing litigating parties to agree on an alternative jurisdiction. So that's set out in the cascade that Sebastian described earlier. In other words, they can agree on alternative jurisdiction even for pan-EU relief. So our US and UK litigants might choose the courts of, say, Ireland for EU trademark disputes. And it's worth noting that the courts in Germany, in the Netherlands, and the Nordic countries have the option of litigating it in English, which might be of benefit to some of our clients. But obviously the issue of pan-EU infringement and validity doesn't have to dictate the choice of law or jurisdiction clause for the entire contract. And the type of clause chosen will depend what the contract as a whole covers, most probably on the negotiating hand that each party has, and potentially also on whether you think you're likely to be the claimant or defendant if a dispute arises. So whilst it's definitely possible to draft a clause setting out an alternative jurisdiction for EU trademark disputes, obviously care is needed if disputes on different issues within the contract are to be allocated to more than one law, more than one jurisdiction. You could end up in a position where separate actions on related issues are in different jurisdictions. So I'll now hand back to Sebastian, who's going to look at the position on agreements in Germany.
Thanks, Louise. Another key question. Do you hear me? Yeah. Another key question that arises is whether an agreement that refers to the EU will continue to extend to cover the UK after Brexit. I look to that question from a German perspective, but I think many continental jurisdictions may have the same approach or an equivalent approach. If you want certainty that the UK is included after Brexit, you should use clear language in your contracts and agreements from now on. This is an example, which you see now, of such clear language that removes room for doubt. So the clause could read as follows: this agreement applies in the European Union in its current and all future extensions, including in the United Kingdom and in any other current member state of the EU, even in case they should exit the EU in the future. By the way, there is some added value in this wording. Depending on future developments, this wording also covers events such as Plexit or Czexit or other potential exits. But many existing agreements are not so clear. It is not uncommon to find this sort of language. This agreement applies within the EU, or this agreement applies in all member states of the EU. Provisions like these are unclear. Will the UK still be covered after Brexit or not? Assessing whether it is the one or the other is a matter of contract interpretation, and that requires a case-by-case analysis. There are, of course, factors clearly in favor of the UK remaining in scope of an agreement. For example, when the background of the dispute leading to the agreement was a mainly UK-related conflict. Or another factor in favor of the UK remaining in scope is when the agreement refers not just to an EUTM, but explicitly refers to national UK trademarks of the parties. However, often risks and legal insecurities will remain. We recommend reviewing the territory provisions of existing key agreements. Depending on the results of a case-by-case risk assessment, you may then wish to clarify future territorial scope and whether UK comparable rights shall be covered as well. You can do so, for example, by way of supplementary agreements or by way of side letters. Louise will now address a slightly different situation for contracts under English law.
Thank you, Sebastian. So as far as existing agreements are concerned, the UK has included some provisions in its Brexit IP legislation to help with contract interpretation. So these provisions apply where there's a licence, a consent, a security interest, or any other document that's governed by English law and is in existence at 31st of December this year. Where one of those documents covers or refers to an EU trademark or registered community design registration, it will automatically be deemed to cover the new UK rights that are being created as well. There are some caveats. So, for example, if there is a licence which refers to an EU trademark registration, that will, as I say, be deemed to cover the comparable UK registration, but that's subject to any agreement to the contrary and depends on the context of the licence as well. But broadly, any reference to an EU trademark or RCD registration will be deemed to cover the new UK rights that are being created. So these new provisions are helpful and they should help with some issues of contract interpretation. Obviously, they're not a complete answer. It's worth just noting that provisions only apply to references to EUTM and RCD registrations. So if a document refers to an application, the provisions don't kick in. Likewise, they don't kick in where there's a reference to an unregistered right, such as an unregistered community design. And similarly, if there's a reference to the EU, the new rules don't tell us anything about whether that should be interpreted to include the UK or not. However, in these circumstances, the normal English law rules on contract interpretation will obviously apply to help interpret those terms. And in most cases, we feel that should give the right answer. So in view of that, we don't see any need to do a whole-scale review of all of your English law governed agreements. However, you might find it useful to check your key agreements still work, and if any doubt, execute a side letter or clarification as Sebastian described. I echo what Sebastian said about future agreements. Going forwards, agreements will have to deal with UK and EU rights and territories separately. Where there's a reference to a particular piece of EU legislation, might also need to include the UK equivalent of that legislation. And obviously, jurisdiction clauses will need to be carefully drafted as described above. So that brings us neatly to the end of our presentation, and I'll hand back to Sebastian.
Thanks, Louise. And that brings us to the end of today's presentation. We've had, however, some questions come in, and we would like to address them now. I suggest I read them aloud and hand them to you, Louise, or you, Roland, whatever fits better. So the first question which came in is, how quickly will the EUTM registrations be turned into UK comparable rights by the UKIPO? And I guess this is one for you, Louise.
Yeah, thanks, Sebastian. Well, the UKIPO hasn't given any concrete commitments on this, but I'm certainly expecting the new rights to be reflected on the electronic database overnight. I know that the UKIPO has been recruiting and has got its technology in place to do this, so I'm expecting it to be an overnight thing. You won't get any registration certificates for these new comparable rights, but I think you can request a registration certificate if you need to prove their existence.
Thanks, Louise. And there is another one I think you are best prepared to answer, Louise. So the question, or the comment and question rather, is I've read that my UK representative can continue to act on my EUIPO case after Brexit if the decision is appealed. Is there a time limit on that? Louise, can you answer that question, please?
Yes, sure. So presumably this relates to actions that were pending at the end of this year and the right of your UK representatives to continue to act on that. And you asked whether there was a time limit on that. So no, there isn't. Your UK representatives can act in all stages of a matter as long as it was pending on 31st of December this year. So they could act in any appeal to the Board of Appeal or to the General Court or to the CJEU. So I guess this could mean that your UK representatives are continuing to act for you for a number of years, maybe 2022, 2023 even. And that applies to obviously pending applications, so prosecuting those through to completion and all of your disputes in and out as well.
Okay, thanks, Louise. And well, quite many questions. Another question, which is, can you split your jurisdiction clause in an agreement if a dispute relates to the validity or infringement of the EUTM is covered by an EUTM court, but the rest is covered by English law and dealt with by the UK court? I guess, Roland, perhaps you can answer this question. Roland?
So I guess I'm not sure whether we've still got Roland there. Roland, I don't know whether you're on mute or... Okay, so I'll answer that question.
Perhaps you take it. Yeah.
So yes, in theory, you can have this sort of split jurisdiction clause, which I think is what you were referring to. So you could have jurisdiction for validity and infringement of the EU trademark being dealt with by one court, and the rest of the issues that might arise under the contract covered and dealt with by the UK court. Yes, that's possible. Another option is to have the agreement itself governed by English law and have non-exclusive jurisdiction of the English courts for disputes arising out of it. And that would leave the option of an EU trademark court to deal with any infringement or validity issue. But it would be preferable to specify which one, I guess, not least if you have a language preference for the litigation.
Okay, thank you. And there are two more questions, and I think we have enough time to address them, and they seem related. So the first one is, do you think the EU 27 EUTM courts will readily enforce a pan-EU injunction issued by an English court in 2022, where the case had been started this week, or likewise, would the EUIPO recognize it as then, which invalidated the claimant's EUTM? And I think I can address this. It relates back to an issue we raised before. And that's the issue of whether the UK courts retain the international jurisdiction to grant pan-EU relief, or even to decide on counterclaims on validity of EUTMs in pending proceedings, meaning proceedings pending on the 31st of December 2020. And our reading of the withdrawal agreement is that the English court will retain the power to make those orders. And so I would expect the German courts, for example, to recognize and enforce such an order as if the injunction had been awarded today or last year. But there haven't been any statements on behalf of national European trademark courts or the Commission specifically on that issue. On the other hand, the EUIPO's Brexit commentary indicates that it would indeed implement such a decision provided the action started before 31st of December 2020. With regard to the specific issue of a counterclaim and a decision on the validity of a EUTM, in that context, there is a question mark whether the counterclaim has to be pending at 31st of December 2020, or can be whether the counterclaim can be filed later on. So there is some legal insecurity there. So the last question is somehow similar. It reads, whether European Union trademark proceedings are initiated in a non-UK country, for example, Italy, prior to 31st of December 2020, but decided after that date, will the decision likely cover the UK as well as the remaining EU 27? Roland, are you back in? Perhaps you can address this last question. Oh, yeah, good. We can hear you.
Thank you.
So please take the last question.
Okay, so that question, I think that looks to be a flip of the one before, really, in some respects.
Yeah.
And essentially it's mutual. So essentially the decision in Italy made, next year or even in 2022, that decision ought to be implemented and respected by the UK courts, much as as Sebastian was saying, that the German or national courts in the EU 27 will implement the UK decision. These are all assuming, of course, that the action is pending on the 31st of December. So, yes, I think is the answer to the question.
Yeah, I share this view. Yeah. Okay. I think that's all the questions which came in, and we answered many of them. So we'll make the recording of that webinar available, so you can re-watch it or pass it on to colleagues. And we are happy if you send us further questions, and we will try to answer them right away. We would be, as mentioned before, we would be grateful if you could give us feedback on this webinar. You will receive an email to this end later on. And this just leaves me to say thank you for watching this webinar, and thank you to Louise and Roland for joining me on it. Goodbye.